Thank you, Evelyn. It is really an honor for me to be here with you all for this annual meeting of national equality bodies in Europe. Your organizations serve a vital role as catalysts for equality, and I am looking forward to this chance to engage, to learn more about what you do, and to share with you some of the strategies that we're using to advance our common goal of equality. I've been asked to share a few words about the Equal Employment Opportunity Commission and to talk about some of the challenging issues we're facing. It was very interesting to hear about the trends that you're seeing across Europe. I would share that we have had, I think, a growing awareness across the United States, particularly of concerns of racial discrimination. For those of you who may be aware of some of our news, we've had quite a number of incidents throughout the year with racially charged conflicts, some spurred by concerns of policing and the death of unarmed African American citizens. So those incidents in particular, I think, have raised awareness about existing problems of racial inequality. And we saw a recent survey from just a month or two ago that showed about a 50% increase in people's view that racism is a problem in America. The percentage of people thinking more needs to be done went from about 26% to about 50% in a matter of several years. So we do think that there is this growing awareness in our country of the need for us as a society to do more to address these issues. We have a interesting role within the United States. We are an independent commission, so we're the organization within the United States government focused on enforcing our equal employment opportunity laws. We have a structure that is a 5-member bipartisan commission, so whoever's president appoints 3 members of his own party and then 2 members of the other party. And so all of us are appointed by the president, and I'm serving as chair of our commission. And the commission sets the policy for the agency. We have about 2,300 employees around the country in 53 different offices. And we have the opportunity for people to come in and file charges with us. People can also access information online. So we have just celebrated our 50th anniversary as an agency this past July. We were created by one of our country's most transformative pieces of legislation, the Civil Rights Act of 1964. Title VII of that act, which governs employment, created our agency. And for the first time, the law made it illegal to discriminate on the basis of race, national origin, color, or religion, as well as sex. So we opened our doors on July 2nd, 1965, 1 year after the Civil Rights Act was passed. So now we've had this chance, 50 years later, to look at where are we and what are our challenges ahead. Over these past 50 years, we've gotten increased responsibility as an agency. So in addition to Title VII, we now enforce laws prohibiting discrimination based on age, disability, equal pay, and also genetic non-discrimination. So all the laws that we enforce also prohibit discrimination based on retaliation. And in fact, retaliation comprises about over 40% of the charges of discrimination that we get. We know that it is vital for people to feel free to come forward to report complaints. So that's an area we take seriously. Our laws cover employers who have at least 15 employees. For almost all of our statutes. For age, it is 20 employees. And our laws require equal treatment in all aspects of employment. So that goes from hiring to promotion, discipline, as well as wages and benefits. Our agency promotes compliance in several ways. We provide guidance on how to interpret the law. And we also conduct outreach and education for employees as well as workers. And we do collect employment data. We started in 1966 collecting demographic information from employers. So each year, employers with at least 100 employees report to us the number of employees by race, ethnicity, and gender in 10 different occupational categories. So we look, for example, at professionals or service and maintenance workers to have an idea of where we may have occupational segregation and to see the trends across time. We share that data also with academics who use it in their research. But probably the bulk of our work goes to investigating complaints of discrimination. We have a complaint process where individuals can come in and file a complaint that we will investigate, and we make a determination as to whether reasonable cause exists to believe discrimination occurred. We also have the authority to open an investigation on a commissioner's charge. So any member of the commission who learns of a problem can also file a charge that we can investigate. And under some of our statutes, including equal pay and age, our offices also have the ability to open a directed investigation. So this allows us to move forward even where people are afraid to come forward and do not want to file a charge. So that's important for us as well. When we were first created, we did not have authority to file a lawsuit in court. And that authority didn't come until 1972, when it was recognized that we needed that additional enforcement authority to more effectively enforce the law. And so now where we find reasonable cause to believe discrimination occurred and we're unable to resolve that charge, we can file suit in federal court, our national courts, and the court will then decide the issue ultimately. And at the same time, in 1972, when we got litigation authority, we were also given the responsibility for enforcing our laws in the federal government. Because our federal government is the nation's largest employer. We, as a government, we employ over 4 million employees. And we have a separate complaint process for federal employees. So employees who want to file a charge and have an administrative hearing can do that. We have administrative judges who are employed by the EEOC around the country who can issue an opinion about whether discrimination occurred. Appeals of those decisions are ultimately decided by our commission. And then if an employee is not happy with that decision, the employee can still go to court. The employee can choose not to go through our hearing process and go directly to court, or at the end of the process can choose to go to court. However, the government is bound by the EEOC's decision through the administrative process. And what we've seen throughout our history is that the demand for our resources has exceeded, in many cases, the resources we have. It was projected in our first year that we opened that we'd have about 2,000 charges, and in fact we received over 9,000. And now the charge rate has increased by about tenfold. This past year we received about 90,000 charges of discrimination in our private sector process. And so in order to meet this demand, we have roughly what we call 575 available investigators, so fully trained investigators working in that capacity. And we adopted a strategic plan and a strategic enforcement plan to focus our work on areas where we believe the government could have the greatest impact, both with the knowledge we're obtaining from charges around the country and the ability to investigate and get information. We do have subpoena authority during our investigation, which can help us get some of the data we need to understand broader problems. So we identified 6 areas. The first is eliminating barriers in recruitment and hiring. This is often an area where it's very hard for individuals in the private sector to pursue claims because they don't know why they weren't hired and they don't have broader information about what might be happening in that employer. The second is protecting immigrant, migrant, and other vulnerable workers. The third is addressing emerging and developing issues, and we have identified coverage of LGBT individuals as one of those areas, as well as certain disability employment-related issues. The fourth is enforcing equal pay laws. The fifth is preserving access to our legal system. So that includes things like overly broad waivers, as well as various kinds of policies, including some arbitration agreements that may prohibit people from filing a charge, which we don't believe is permitted. The sixth is preventing harassment through systemic enforcement as well as outreach. So these are areas where we are having our offices around the country focus in order to have a more sustained impact in promoting compliance. So to give you a sense of our work, this past year we recovered over $400 million for individuals, both through our administrative process and through litigation. And we also work to change the practices that are causing the problems. We call that injunctive relief, and that's an important part of the remedies that we seek. We work to resolve charges as early in the process we can. We have an administrative process, and we can settle that charge through a mediator. We have mediators on staff. We also hire outside mediators. And once we find reasonable cause, we have a conciliation process where we again try to resolve that charge. And in fact, most of our work is done through that administrative process. For every one lawsuit we file, we're resolving over 100 charges through that administrative process without having to file in court. So we do select the cases that we file very carefully, and on average, in recent years, we have filed about 133 cases. A few years ago, maybe we filed over 300, but what we've been doing more now is focusing on larger systemic cases. So those often are cases we're litigating for a number of years about larger practices. But we have had a high success rate, and in over 90% of our cases, we've reached a favorable resolution or prevailed on average over the past 5 years. So I wanted to share with you some of the examples of the kinds of issues that we've been working on and the strategies that we are using. And one of the most dynamic areas of our law right now involves the rights of LGBT individuals in the workplace. Many early interpretations of Title VII's prohibition against sex discrimination did not interpret it broadly. And it wasn't until the 1989 decision by our Supreme Court in Price Waterhouse versus Hopkins, the courts adopted a broader understanding of what sex stereotyping is. So in that case, a woman named Ann Hopkins was up for partnership at this accounting firm. And she was rejected because male partners found her too aggressive and abrasive for a woman. She was told that her partnership was on hold until she changed the way she presented herself, including walking and dressing more femininely, styling her hair, and wearing makeup and jewelry. So the court held that that was discrimination based on gender stereotypes. They heard testimony from social psychologists who talked about that phenomenon and found that that kind of sex discrimination by stereotyping is protected under Title VII. And then nearly a decade later, in 1998, our Supreme Court in On Call versus Sundowner held that Title VII prohibits sex-based harassment even when both the perpetrator and the victim are of the same sex. The court explained that even if Congress had not contemplated same-sex harassment at the time, Title VII must extend to sex-based discrimination of any kind that meets the statutory requirements. So we have, at the EEOC, have applied these precedents to 3 recent cases where the federal government was the defendant, and employees alleged that they were victims of discrimination based on sexual orientation or transgender status. So in adjudicating these appeals of federal employees' cases, the commission found that Title VII prohibited sex discrimination based on transgender status as well as sexual orientation. We don't, as many of you know, have any national law in the United States that explicitly prohibits discrimination based on sexual orientation. But we have looked at the prohibition in Title VII against sex discrimination and interpreted that to include discrimination based on sexual orientation. So let me walk you through briefly these 3 cases. In 2012, in Macey versus Department of Justice, we held that discrimination based on gender identity constitutes sex discrimination. So there an individual was offered a job as a male, and then once starting had transitioned to be a female. And on that basis, the agency rescinded the job offer. And we found that that was discrimination based on sex. Then in Lusardi versus Mchugh, Tamara Lusardi was denied access to a female restroom following her transition from male to female. She was also subjected to offensive slurs and was intentionally addressed using the wrong pronoun. So in this April, the Commission held that these factors constituted sex-based hostile work environment discrimination under Title VII. And then in July of this year, we decided a case in Baldwin versus the Department of Transportation, which held that sexual orientation discrimination is necessarily discrimination based on sex under Title VII. So we explained in Baldwin that sexual orientation is inseparable from and is inescapably linked to sex. And therefore, the allegation of sexual orientation discrimination involves sex-based considerations. The decision sets out three bases for these conclusions. The first is that sexual orientation discrimination is treatment that would not have occurred but for the employee's sex. For example, the discrimination occurred only because the employee was a man dating another man instead of a woman dating a man. The second basis we outlined is known as associational discrimination. So it could also be viewed as discrimination because the sex of the person that someone is associating with is taken into account. Our case law has clear law explaining that, for example, it is race discrimination to fire someone because they are in a relationship with someone of a different race, right? And that is recognized as race discrimination. So we're applying that same reasoning to find that this could also be sex discrimination. And finally, the third basis is that, relying on that Price Waterhouse case, that this kind of action is inherently based on sex stereotypes about who a person should be attracted to. So although these cases all arose in our federal sector, we take the same position in our private sector litigation. And we have filed actions on behalf of transgender individuals and also briefs in the appellate courts on a number of these issues. Now, our federal courts have reached differing conclusions about whether sexual orientation in particular is protected. There is more case law protecting transgender individuals, in part because the sexual stereotyping analogy based on Price Waterhouse is more developed in our law. But a number of federal district courts, our trial court level around the country, have found that sexual orientation discrimination is prohibited under Title VII. At the appellate level, we haven't yet have a court recognize that. And in fact, we've had some courts explicitly say sexual orientation is not protected. But as we explained in our Baldwin decision, many of those appellate court decisions were decided before Price Waterhouse and the sex stereotyping guidance that case provided. So those decisions have not had the benefit of that analysis, and then many of the cases applying that have not either. So I think this is a very interesting area where the law is continuing to develop. Another important development we've had in the United States is a presidential executive order that President Obama issued in April of this year on LGBT workplace discrimination. It prohibits companies who receive federal contracts from discriminating based on sexual orientation or transgender status. So this will cover many LGBT workers who build our highways, provide supplies, staff our cafeterias, and many other roles that contractors play in our society. So we have on our website a resource document that collects many of the cases and others that I mentioned today. It's called What You Should Know About EEOC Enforcement of Protections for LGBT Workers, and it has comprehensive information about our work in this area. Another area I wanted to highlight for you today is our work on behalf of immigrant workers. I know that immigration and the rights of immigrant workers are central issues in Europe right now, and they are also critical in the United States as well. As I mentioned earlier, we have a strategic enforcement plan that identifies protecting the rights of immigrant workers as one of our national priority areas. In our law, immigrants are protected from employment discrimination regardless of their immigration status. So whether they are documented or undocumented, which you may refer as regular or irregular, temporary workers or guest workers are all covered by our laws. And we know that we have to protect the rights of all workers, because leaving any group of workers unprotected, particularly some of our most vulnerable workers, harms all workers by creating a race to the bottom and lowering working conditions. So we don't inquire into a worker's immigration status when we investigate charges of discrimination. And if we bring a lawsuit, we work to try to keep that information out of court. So I wanted to share a few examples of our work in this area, particularly with some of our most vulnerable workers. We've had a number of cases raising issues that are associated with trafficking. We have authority under our Title VII prohibition against discrimination based on national origin. Because often what we see is that people are brought in from a country and treated much less favorably than American workers. And so that is our statutory authority. For example, last year we settled a case against 4 farms operating in Hawaii, including Global Horizons and Del Monte Fresh Produce. On behalf of Thai farm workers, we obtained about $3.6 million in a first settlement, and these individuals were charged exorbitant recruitment fees and essentially were held in debt bondage. They had their passports confiscated and their movements monitored, and they were subjected to production quotas not imposed on non-Thai workers. They were deprived of food, water, and safe living conditions. So our settlement encompasses both monetary relief, options for jobs and benefits, housing, other reimbursement of expenses, and other injunctive relief to prevent that from happening again. The court also found the labor contractor, who's the person that supplied the workers to the larger farm, liable and entered a default judgment in total for over $12 million. So that's another area where we've seen problems, often with a contracting relationship that we're seeing with increasing frequency in many of our industries, where larger companies are hiring labor contractors to provide temporary workers. So in addition to workers who are being trafficked into the country, we also see discrimination facing many immigrant workers in fields like farm working, janitorial industries, and others. And particularly where women are isolated, we've seen increasing number of cases involving rape and sexual assault. So often in these cases, we have been the only hope for justice. Many times people are reluctant to come forward to bring criminal prosecutions, or by the time they come forward, the evidence that they have is old. So last month, we won a unanimous jury verdict against another farm, Moreno Farms, awarding over $17 million to 5 former farm workers in Florida. So we allege that 2 sons of the owner of the farm and a 3rd male supervisor engaged in sexual harassment, including sexual assault, against female workers who were ultimately fired for coming forward to complain of the discrimination. So these cases, we were able to really make some inroads because we had people on staff who were attorneys who came from the farm working community and were able to go out and build trust out in those communities. What we recognize is that for us to reach particularly newer communities, we need to make sure we have people on staff who understand the community, who speak the language spoken in that community, and that we're affirmatively getting out into the community, because we know people will not generally want to come forward, and there's a lot of wariness about working with the government. So we now have many investigators with different language skills, and we've translated, basic information about what we do into 21 different languages. Much of that information is available on our website, and we also go out into communities to do outreach. Another important issue that we have been seeing more of is discrimination based on religion. Earlier this year, we had an important victory in our Supreme Court against Abercrombie & Fitch. Our charging party in that case, Samantha Eloff, wore a headscarf every day since she was 13. And when she was 17, she applied for a job in a store in her local mall in Oklahoma. And we brought a case on her behalf which alleged that the assistant manager who interviewed her thought she would be well qualified for the job. But when she told the higher level manager that Samantha wore a headscarf, that manager said, "Oh, you know, we should take points off her application because that violates our look policy." Because Abercrombie had this policy that required a particular look that did not allow the wearing of caps. And they interpreted caps to include headscarves. And so they denied her the job on that basis. And the Supreme Court found in our favor in that case, finding that an employer may not make an applicant's religious practice, confirmed or otherwise, a factor in employment decisions. So after that oral argument, Samantha told reporters, "I am not only standing up for myself, but for all people who wish to adhere to their faith while at work." So we think that is another important clarification that will help people of all religious backgrounds in the workplace. I wanted to touch briefly on a few other areas as well, and then I wanted to leave questions to hear from you about the work that you're working on as well. As I mentioned earlier, we have seen an increase in awareness about problems of race discrimination. Charges involving race continue to be a significant part of our docket. About 35% of all charges we receive allege race discrimination, and that's under all the statutes we enforce. And we see that discrimination both in overt and more subtle forms. This April, for example, we settled a case for about 1,000 employees of a drilling company, alleging race and national origin discrimination. We alleged a nationwide pattern or practice of harassment, and also discrimination in assignments of African Americans, Native Americans, Hispanics, as well as Asians. The employer agreed to pay $14.5 million to these individuals and to make significant changes to its practices. We also see hiring discrimination, and one of the patterns is often that people who are not white are given the jobs in the back of the restaurant, and the people who are white or of a particular background are given the front of the house customer-facing positions that provide higher wages and greater advancement. So, for example, in September, we settled a case against a nationwide seafood restaurant, which we allege refused to hire any African Americans into positions where they would interact with the public. So that consent decree provides approximately $1.3 million to over 200 individuals who we allege were denied those opportunities, and requires significant changes to those practices. We also continue to see what is more subtle discrimination. There's been a lot of research on implicit bias and how it plays out in the workplace. And that, I think, is one of our greatest challenges going forward, is identifying the practices that allow decisions to be made in a discriminatory way, as well as the kind of guidance that can be given to counteract what we know are natural sort of decision-making processes that will happen within the absence of that guidance. Sex discrimination is another area where we continue to see challenges for women. We, as I mentioned earlier, collect data on demographic patterns, and we found, for example, that the participation rate for women professionals in the workforce has skyrocketed over the past nearly 50 years. We had about 14% of professionals as women in 1966, and now in 2013 that had skyrocketed to more than 53% of the professionals. And although women are nearly half of our workforce, they continue to be concentrated in lower wage jobs as well. So we're challenging practices that we see denying women hire in traditionally male fields. Many of the jobs that require lifting, truck driving, construction, jobs that are traditionally associated with having strength. There are some companies that think women can't do those jobs, even where they have had prior experience and are interested and qualified for that work. So we find women being denied hire. Those who are hired often face sexual harassment or denials of training opportunity to allow them to advance in these higher paying fields. And one of the most overt forms of discrimination we continue to see is in pregnancy. Over 70% of the pregnancy discrimination charges allege termination as a result of pregnancy. We also see harassment, forced leave policies, demotions, and other types of discrimination. And to counteract some of that, we updated a pregnancy guidance that the Commission issued over 30 years ago, identifying protections for women, including for nursing mothers, as well as women who may have temporary disabilities that require accommodations while they're pregnant. So our U.S. Supreme Court heard a case, Young versus UPS, this past term, which also set forth a more clear standard that allows accommodations for pregnant women, which we think is very important. And the last area I wanted to mention is our disability work. This was the 25th anniversary of the Americans with Disabilities Act this summer. And that was a landmark piece of legislation that we have seen made great progress for people with disabilities entering our workforce, but we still see significant challenges, both in hiring as well as advancement to the highest levels. We see denials of accommodations as well as stereotypes and myths about the abilities of people with disabilities that keep them from hire in many workplaces. So we do bring about 35% of the lawsuits that we bring involve disability issues because there are many areas of the law that are still being clarified under this area. And we know that there are also people with severe intellectual disabilities who are being abused. In a similar way to some of our trafficking cases, we had a lawsuit filed on behalf of 32 workers with intellectual disabilities who were subjected to harassment in a processing plant, and they were subjected to substandard living conditions and were restricted in their freedom of movement. And through that, we won the largest verdict in our history on behalf of workers, $240 million on behalf of these workers, although that was later reduced due to our statutory caps. But in closing, the work that we've done over the past 50 years has furthered the understanding of equality in our society. We know that there is not a single answer to ending discrimination. And we know that from our history that advances in equality are not inevitable. They require constant vigilance as well as the commitment and organizing of many. So within our respective countries, I know that we face many similar challenges. And I believe that with the commitment of organizations like yours and ours, we can make real progress on some of the greatest challenges that continue today. We all work to shine the light on existing barriers to opportunity. And by sharing our collective knowledge, I believe we can meaningfully advance equality throughout our society. So I very much look forward to meeting with all of you, and I hope this can be a beginning of a broader conversation between the work that you're doing in Europe and ours at the EEOC. So I thank you very much for having me, and I would look forward to any questions or to hearing about any work that you're doing in your countries. So thank you.
If you want to stay there, I'll ask for any questions or comments. I'll just use big voice, but there are roving mics. But let me say, first of all, Jenny, thank you very much for a fascinating overview of your work. To have condensed so much into 30 minutes is really impressive, so thank you for that. I think we're all a bit taken, certainly I am, at the scale and scope of your work across the whole of the US, and really interested in how many common themes there are with the work of equality bodies in Europe and indeed with EQUINET. For example, just in the last few months, we've looked at the growth of work on religion and belief by equality bodies in Europe, and the perspective on that is available today for the first time. In the summer, we looked at work-life balance
the issue for many equality bodies absolutely is pregnancy discrimination.
Right.
EQUINET has contributed this year to the European Commission's thinking on its disability strategy, again by gathering the work of equality bodies on disability. So really, a lot of common themes on both sides of the Atlantic. And the other one that I picked up, and I very much welcome comments from colleagues from other bodies, is this big issue, we would call it underreporting, but the importance of equality bodies reaching out to ensure that those most vulnerable, who may not think, may not know, may not trust to come to an official body, actually have access, and your work on that is most interesting, and again, an issue for us in equality bodies about reaching out to the most vulnerable. So, any comments from the colleagues while we have 5 or 10